Welcome to the single justice session of the appeals court. I am Judge Rubin. And we are hearing argument this morning in JOLLEN KURTZ, DBA Chatham Lodging versus EDUARDO and another, number 23J 289. Now, the way this is going to work is a clock will appear in the box that now says Massachusetts Appeals Court that will count down from 10 minutes. And each of you will be given 10 minutes to tell me what you have to tell me. Now, Ms. Eduardo, I know you are representing yourself. And I just want you to know that I understand how difficult that can be to represent yourself in court. It can be intimidating just talking to a judge, I know. And of course, without legal training, it may be that you don't know exactly what the proper legal points to address are. And so I understand it's very difficult, and I will try to do whatever I can to make it a not unpleasant experience for you.
Thank you.
So this is an appeal from the denial of a waiver of an appeal bond. And so in such a hearing, there are two issues that I have to consider. The first is indigency, and the second is whether there is a non-frivolous defense that can be raised on appeal from the underlying judgment, the judgment for possession to the landlord. Now, I think indigency is not contested here.
That is true.
And so I will, we don't need to focus on indigency, as I will find that the petitioners are indigent. So the real issue before us is, are there non-frivolous grounds for appeal from the underlying judgment? And I am going to turn first to you, Ms. Eduardo, and we will hear from you for 10 minutes.
Thank you, Your Honor, for your words. And
I should also say, I'm sorry. But let's wait.
Sorry, I was timing.
No, that's okay. You filed a motion for a continuance or a stay to get the transcript. And it may be, if we wind up focusing a lot on this question of COVID affecting your economic situation, it may be that I need a transcript to resolve that, although we'll talk about it and we'll see. If at the end of the day, I conclude that I need to see the transcript, I will wait to get the transcript before ruling. But the motion for continuance or a stay right now is denied, and we're going to go ahead with the hearing. And I suppose, although I think it will be unlikely, if after seeing the transcript, I need to hear from you all again, you'll hear from the court and, like that. All right. So with that, I'm sorry. So that's denied, and you can begin.
May I give you an update on the transcripts?
Sure.
I was in touch with the office that provides the transcripts yesterday and today, and they advised me that the transcripts will be available by the end of the week.
Great. Okay.
I can send you that email if you need that.
No, I need the transcripts, but I don't need the email.
Okay.
I may need the transcripts. All right. So go ahead.
Okay. So I will start with the one reason in the court's order for the assertion that the defenses in this appeal are frivolous. Essentially, that is that the arguments and the evidence that we presented at the bond hearing were not previously presented at trial. So that was the reason in the order. So I would argue that that should not have been asserted without a reading of the trial testimony, because it would be impossible to know what was and what wasn't presented at trial without reading the transcripts, which we know are not.
The judge, I can't tell, but the judge was there at the trial, right?
No, that it was a different judge. It
Really?
was, yes. So the first judge was Del Puerto, and the second judge was Theophilus. I can give you a better
Yeah.
pronunciation. Okay.
Let me ask you this. Of course, in the judgment itself, the original judge said that at least that you hadn't raised the COVID issue, I think, right? Or that you had said that you.
Well, what the judge said at the beginning of trial, before testimony, before the first question from anyone, and I was sitting in the witness box, he stated, this is my recollection, I don't think that 257 applies here. That was that, and that's
well,
so
of course, I may have to look at the transcript to sort this out, because I assume Attorney Poor will tell me that it was clearer than that, the question that was asked. But all right, so let me also ask, well, you keep
and
talking.
I do address all of this in what I'm sort of have prepared to tell you.
Okay.
So basically, again, that it would be impossible to know, my assertion is, my response to that is that it would be impossible to know what was said. And it's true that we did respond to the plaintiff's opposition to this waiver with additional evidence. But that additional evidence was not only a direct response to the opposition, it substantiated the issues that were presented at the trial. So, for example, it included emails pertaining to the raft request that we made of the plaintiff. It included medical COVID-19 invoices from hotels that we needed to be at the Wyndham, which was near Mass General Hospital.
But these were not put into evidence at the trial.
Yes, well, they should have been, because they were submitted for the hearing. I submitted, the plaintiff's attorney submitted an opposition to our bond waiver, and then
No, I'm not talking about it, the bond waiver. I'm talking about the trial, the original trial. Did you testify about the raft stuff?
Yes.
And we testified about the lack of cooperation.
Yes, I have a list of everything that we
about the disability issue, or at least the fact of, and did you submit the emails that you have submitted later, or just oral testimony is testimony? But I'm just trying to figure out what you told the judge versus what you told the second judge. Okay, so I do want to concede one thing here, in all honesty, that the issues of condition were not at trial. Okay. So that is something I mistakenly included, learning now from the judge's remarks. But the remaining evidence that was at the bond hearing pertained to what was presented at trial, and because we did testify to medical emergencies that began with an aorta dissection. That was on that happened on September 22nd of 2020. That was the height of the COVID pandemic emergency, particularly for the hospitals. Sure. And there were months of surgery delays during this emergency that caused what we're saying, that, or what we're trying to provide evidence for, is that they were out of the ordinary financial hardship. It actually continues to require us to stay at this extended stay residence. His last surgery was 6 months ago. So it would be the third surgery that he's had, with the second surgery being what's called an open repair and a prosthetic transplant of his aorta. What hospital are we talking about? Mass General Hospital. Okay. For all three surgeries. We began at the Wyndham, which was right next to the hospital, waiting for the transplant prosthetic. And then after his second surgery, we moved further away from Boston because it was getting more and more expensive as more and more people were coming back to the city. So we continued to go further out, and that's how we ended up in Billerica. Can I ask you, your time is running fairly short, although we'll go over by a little bit if we have to. Okay. I have two questions for you. can you explain this business where the lawyer for the day or something came in and talked about discrimination, and the judge said something like, "I'll have a look at it" or something?
Okay.
I mean, and I'll ask Attorney
Sure.
for recollection as well, although of course a transcript would be better, but
Right.
go ahead.
So on the day of the trial, we had about 3 minutes with the lawyer for the day. And I brought up that I had learned in the meantime, in the interim between the answer form and appearing for trial, that what they did was considered discrimination based on rent payments. So I'm not sure I'm saying that right, but so when I brought that up to her, I said, you know, I didn't check off this box on the answer form. And she said, here's a form. You can go inside and ask the judge if, I think I asked the clerk as well, but ask the judge if he'll allow you to amend the form. So the only opportunity I had to speak with the judge about that was when I first sat in the box. So he first said something about the 257, and then I paused. I asked him if I could ask him whether or not I could amend the form to include the discrimination. And he said, I remember, absolutely not, is what he said. Okay. And then I moved on. I didn't ask him. Does that answer your question?
I guess I thought there was something where he said to the lawyer for the day or something. He said,
oh no,
look,
no.
Or does he not, he didn't say something like, I'll have a look at this.
Oh, he said that to me. Yes. He said, when I asked him to allow me to amend the form,
yeah,
he just made this blanket statement. Oh, I'll look at this later.
I thought you just said he said absolutely not.
He said absolutely not, and I said, but I put it in the form that I applied for RAFT, and he said, I'll look at that later. So all that happened at the very beginning of trial. He stated that 257 didn't apply. Then I asked him if I could amend the form.
But you also told him you had put the RAFT business in the complaint, in the answer.
Yes, it was clearly, I actually put it.
I do see it in the answer.
Yeah.
But let me ask you this also, and I'll give you a minute or two to go over if you need it, and I'll give you the same attorney for. Use and occupancy was set at $121 a day. Do you you say something about setting it at what they used to charge you or something?
They used to charge $121 a day, but in the original order, it was requested that we pay 1 month in a couple of days. So yeah. 121 times 30, and then another month a few days late after that. But that was amended by the judge after we filed this appeal.
So you have no issue with the use and occupancy amount or schedule?
For the 121, that's a correct amount.
Okay, and you understand that whatever happens with the rest of the bond, you have to pay that or your appeal will be dismissed.
I do understand that.
Okay.
And that would be per your ruling.
Not for the whole.
Well, yes, if I rule that way, but you're not telling me that it's wrong or not to do it.
No, I'm not.
Okay. And you can pay that?
Yes.
Okay.
So I want to just add the other things that were brought up at trial that that we provided evidence for. We did discuss the RAFT application pending because the plaintiff refused to make that accommodation to label the letter they gave us a rental agreement. So we did discuss that. Even if I wasn't allowed to amend the answer form, it was part of the trial testimony that they gave us a hard time about giving us the documents that we needed. I think I just need a minute or two.
That's okay.
So in addition to all this being part of the trial, and I wanted to address that with whether or not it should have been deemed that it was frivolous. The order also reiterates the plaintiff's claims, some claims that the plaintiff made, that we were asked, that we were, I'm quoting, we were squarely asked, and that we answered no to the question about financial hardship due to COVID. And I strongly believe that the transcripts will show that this claim is false. It's just that simple. We did not
No,
say
I
that.
understand that. And if it comes down to that, I have to think about what the right approach is, but you are certainly differing with each other about what was said at trial. And so
Yes.
that makes it difficult for me to figure out.
Yes.
Right. I mean, there is this transcript coming though.
Okay.
But I understand that issue.
In addition, one of the plaintiff's witnesses that was at the bond hearing was said to have heard this interaction, that we said no to that specific question, that both of us said no to that specific question about COVID's impact. But this particular witness was not even present at trial. He was not there. So I think that's important to note.
Who is the witness?
He's the current manager. His name is Ricardo Santos. Mm-hmm. And he was not present at the original trial to testify that he heard us answer no.
Okay. I mean, it's odd to take someone's even sworn testimony about some phrase in a trial rather than looking at the transcript, which is the official record of it. And I understand because I face the same problem here, which is, and yet we don't have a transcript.
Right.
Like, I'd like to know the answer to exactly what was said by whom, but
right. But it is.
Today, I don't. Okay. I understand that.
Thank you. So also, the transcript will corroborate that the judge, we already talked about that what he said at the beginning of trial regarding 257. The other thing the order does, and it reiterates the plaintiff's claim that non-payment of rent consideration does not relate to whether the judgment should enter. That's something that's on page 3 of the order. And it does, per legislation, that can be read on mass.gov. And that's that a pending RAF application has great impact on whether judgment should enter. I'm going to quote
whether judgment should enter. Oh,
yeah.
The original judgment. Yeah. I understand.
Yes. So I wanted to quote from RAF policy because I just wanted to substantiate what I'm saying. What I'm reading from RAF policy is the following: that the tenant may request that the court delay holding a trial in the eviction case. And we did make that request with the clerk who checked us in at the beginning of trial. That was one thing I was aware of. So I made great efforts during the trial. You know, I felt foolish because I was in a crowded room and I was raising my hand like this to get the clerk's attention. And then finally, he talked to me in the vestibule for a minute or two. And also when I checked in, I went to the front and talked to him again. And he said, let the judge know. So he didn't take any action, but he said, let the judge know.
Did you let the judge know?
I don't remember if I said it at the beginning with all what he was saying about the 257 and me requesting the amendment. I don't remember if I said, look, but it did come up in trial that we had a RAFT application pending and that it was the 4th application that we had. It wasn't just that we decided on that day to have a RAFT application the day of trial. It was our 4th, and it was after a lot of back and forth between.
What day was the trial?
February 27th.
Yeah, so I'll ask Attorney Poor, but I do think that RAFT, I'm not sure if that RAFT thing has expired with the end of COVID in April, or but if it was in February, then.
But it was our last. It was our last of the 4. So the first one had been right smack in the middle of COVID.
No, I understand.
Yeah. So also the guidelines say that even if a trial, I'm going to quote again, that even if a trial has been held, the court will not enter judgment against the tenant or issue execution of an eviction judgment. So, okay. And then, okay. I'm going to assert that I think this is very important. So it'll be like 30 seconds. I'm going to assert that the plaintiff exacerbated our financial hardship. And it was capricious. It was refusing to accommodate us with simply labeling a letter that they had already written as rental agreement. And the only speculation I have about it is that perhaps they thought that would endanger them, and by calling us residents or tenants or something like that. But we had already been there way past the point where we were, in fact, tenants.
Was there any testimony about this at the trial?
Testimony about
their failure to,
yes.
And was it like this, about that they wouldn't label something a rental agreement?
Yes, there was. And importantly, we want the court to take notice that this refusal to accommodate us with this letter, where we are now is still getting on our feet. And we would actually be eligible for a second round of RAFT, because 12 rolling months, as they call it, have expired. And we would now be at 2/3 of the damages that were entered as in the judgment. So that would be $10,000 for the first round and $10,000 for the second round.
Well, I'm not going to attempt to settle the case between you all. If you get some money and can reach an agreement with the other side, that, you know what I mean, that would be fine.
Yeah.
All I can do is decide whether the bond should stay in place or not.
Right. But
I
can
adjust use and occupancy if that's an issue.
Sorry. Okay.
All right. So your time is long.
And would we be allowed to ask you for like some breathing room in that use and occupancy ruling, or would that be?
I don't have equitable power to, well, I don't, what do you mean?
Well, I'm not sure if the other judges' use and occupancy would now be required. And so the previous,
I think it's been required since it was entered.
Well, that's what I'm asking. I'm not sure if
I'm not your lawyer, and I'm not,
okay.
you know what I mean, and I don't really, but I'm trying to think. Of course I can adjust use and occupancy, but I don't think it's stayed. I mean, you could call the clerk's office of our court and ask them whether anything that's happened amounts to a stay of use and occupancy. But ordinarily, I would think the bond would be stayed.
I understand that her entire ruling is stayed, given pending your ruling. Is that?
Yeah, that may be right. I'll figure it out. But but you're saying you want use and occupancy to start today, or whatever?
No, we don't want that today.
When do you want it to start?
We want it for you to rule on it when you.
I understand that, but if I rule on it today or tomorrow or on Friday, if I need the transcript and get it, you're saying you don't think the use and occupancy should begin when the judge ordered it. It should begin when I order it. Is that right?
Correct. Yes.
I'm not sure I have the power to do that.
Okay.
I'm inclined to think not, in fact. So let me say
okay.
I have no idea. I would think use and occupancy probably runs from the date of the judgment. But again, Attorney Poor can maybe enlighten me with at least her view on that matter. All right. Thank you very much. Very well argued. I know it's tricky and you're not a lawyer.
Thank you.
We will hear now from you, Attorney Poor. You have 10 minutes, but frankly, if you want 20, I'll let you keep going.
I don't think that'll be necessary, Your Honor, but thank you. First, to address use and occupancy, yes, use and occupancy was supposed to be paid as of June 1st. My understanding that is separate and apart from this bond waiver, but of course I leave that up to you. As of this date, no money has been received. There is an outstanding judgment of over $34,000 at this point, well beyond anything RAFT is able to pay aside from everything else. In this matter, the defendants referenced their motion for reconsideration as grounds for their appeal. The first issue raised by their motion for reconsideration is that the court erred in failing to apply 257 as a viable defense. Certainly, it is our position that the court made no such error. At the hearing, the court asked the defendants directly if the reason for non-payment of rent was in any way related to COVID, and the defendant stated that it was not. As you and I both know, with the COVID protections, this is an important question.
Well, certainly for that statute, of course it is. And let me also say this. I don't know if you have a way you'd like me to resolve this. I have each side telling me something different about what was said at a trial where something was definitely said, but I don't know what it is.
We would be fine with waiting for the transcripts. The reason I am so sure is, as you know, what an important question that is to a trial. I waited for the defendant's answer, and they stated unequivocally.
You know what I mean? But there is a record.
We will rest on that record.
Okay.
COVID. The pending, which was not raft application, was not evidence of eligibility. As the raft.
No, I understand that. Let me ask you about some other matters aside from 257. At that time, did an application for raft not stay or be a defense?
There was no pending raft application at the time of the trial. The exhibit filed by the defendant.
Oh, because it was dismissed.
It was, well, no, the raft application was not dismissed based on the ERAP Hotel Motel Guidance Exhibit, which was filed by the defendant at the appeal. Raft assistance may be used by tenants in a hotel or motel only in limited situations and pursuant to specific requirements.
They say that it's not a hotel. They say it's not a hotel within the meaning of that regulation because it's an apartment hotel and it's more than one room, something like that.
It is not an apartment hotel. It's Chatham lodging. It's a hotel.
I don't know what that is. So
it is a regular hotel with an efficiency apartment.
So it's an efficiency apartment.
Yes, it is not an apartment. It is not an apartment.
I don't know. No, I understand it's not an apartment, but I don't know what the definition is. Let me ask you this. The judge did take or hear evidence, at least, from them. I don't know what they heard from your side, if anything, but did hear evidence from them. They say, you were there, about the alleged non-cooperation of the plaintiff or the plaintiff's agent, the front desk clerk, whoever it was, in getting what they need to complete the raft thing. Is that right?
In order for them to have qualified for raft, which I do want to point out would have been $10,000. That was the maximum that raft was providing.
That may be.
Covered the arrearages, a third of the arrears at best.
Okay.
In order for them to qualify for raft, my client would have had to enter into a rental agreement with them. That is against company policy. Chatham Lodging does not offer rental agreements. There are short-term stay efficiency hotels.
Was there evidence of that at trial?
There was no evidence of any of this at trial, Your Honor, because the defendants never filed a counterclaim. The judge gave them a lot of leeway.
In their answer, I agree, but their answer says, hold on. I have their answer here somewhere, or I did. Hold on. Answer. If you look in their filing, I don't know if you have it before you as a PDF, I do. And it says on page 21, it says, if you look at the writing after, I have other defenses or counterclaims as follows. The landlord has refused to cooperate with documents needed for the raft application.
And that was dealt with at trial.
The rental agreement needed to complete our raft application. So, but the judge didn't make a ruling on that.
I believe because it was never entered as a counterclaim. We did
Well, it's
address
either a
it.
counterclaim or a defense. It's on the counterclaim or defense form, right?
Exactly. Yeah, it was a defense, and the judge did address that with the tenants or with the defendants, but Chatham Lodging has a right to refuse to accept the raft fee.
That's not
There
what
was
I'm saying.
never-
I'm asking whether the judge, when you say addressed it with the defendants in the findings for judgment,
Mhm.
it's not mentioned.
I have no explanation for that, Your Honor.
Okay.
It was dealt with.
Because you have to remember, I'm wondering if there's, the only question I have actually before me is there a non-frivolous issue for appeal?
It would be.
Right.
Yes.
That's all. I not with respect to the going forward use and occupancy, but with respect to the bond. So I'm looking through each of the things in their defense. They also say, I don't know if this was or how it was addressed. The answer also says that they are asking for reasonable accommodation due to disability. I don't know, again, I have to look deeper to know if that's a valid defense or what it is, right? But go ahead.
The reasonable accommodation the tenants are looking for is not paying.
Well,
There was never, that's the only reasonable request. That's the only accommodation we've been asked for. The defendants have never made any request for a reasonable accommodation. No reasonable accommodation was requested prior to the service of the complaint for summary process, and no request for reasonable accommodation has been made since.
but it was made in the answer. So I'm in the answer at page, again, this is a PDF that I don't know if everyone's paging is the same. Page 23. The court should order the landlord to make reasonable accommodation is check number 75. I and or a member of my household have a disability, and I request the court to order the landlord to accommodate the disability by stopping the eviction and or taking steps to provide an accommodation to allow me to remain in my house.
The only steps that could make that possible would be writing off the $40,000+ that the defendants now owe.
Well, I see what you're saying. And again, I don't know anything. I've never seen this as a defense before. In fact, my sense is that the single justice's authority over housing has expanded dramatically since the last time I was single justice. So I've been looking at a lot of these. And your time is likely to expire, but again, we can keep going.
I do want to reiterate, Your Honor,
Yeah.
at the time of the trial, there was no raft application pending at all. The defendants had attempted to file a raft application. It went up to management of Chatham Lodging. It is not Chatham Lodging's policy to ever enter into any kind of a rental agreement with anyone.
Again, let me ask you, and I see this is more about testimony, really, than I hate, you know, I like.
The judge spent quite a bit of time during the trial.
Yeah.
Talking about 257, and the defendants and the tenants there was a lot of discussion.
No, but I'm talking now about the rental agreement, and what I can't figure out is if, and I'm not saying this is the case at all, you can maybe disabuse me of even this possibility. Maybe through their tenancy or whatever, their time there, maybe they and you had a rental agreement. I understand not labeled rental agreement, but maybe you had some kind of agreement. I don't know, because they had been there for a long time, right?
There was no agreement, as when you check into a hotel. You sign in as a guest of the hotel.
Well, no, I agree, obviously, but at least while you're there, I don't know if I'd use the phrase rental agreement, but surely I have an agreement with the hotel. I'll pay them. They'll provide me a room. They won't walk into it without knocking. They, you know what I mean? Whatever the rules are of the.
But there are those are not in writing. I mean, I'm sure you've checked into a hotel.
No, I understand.
There's no rental agreement. There's no agreement for long-term rental.
No, I agree with that.
Actually, because of this case, Chatham Lodging is now not even allowing people to stay for more than 29 days. They've changed their policy completely. Yeah. They have never allowed anyone to become a tenant of the hotel. There has never been a rental agreement, and that's why Chatham Lodging declined to label or to create a rental agreement on behalf of the.
Yeah, I understand.
It's against their policy. They chose not to do it.
No,
as
no,
a
I
result,
get it, and once again, I don't have. I have to look at the transcript. I think at least about this. I see the clerk's office has given you an additional 10 minutes simply by giving you 10 minutes. But you can keep going with your argument to the extent there's more argument.
I just wanted to go over the pending raft application. The second issue raised by the motion for reconsideration were the plaintiff's refusal to accept the raft application, but there's never been any allegations of special accommodations or discrimination raised at all. There is no violations of 257. The third issue raised was identical to the first, as far as the quarterly, whether or not their hardship was caused by COVID, and their direct answer of no, which will be supported by the transcript. Again, the tenants never made any requests for reasonable accommodations. Pursuant to 239 section 3, an appeal may be filed on either or both issues involved or on any counterclaim. In this case, the defendants filed no counterclaims to the original complaint for summary process. The only issue before the court on the day of trial were those brought by the plaintiff seeking possession and rental arrears.
Well, their answer contains what purport to be a bunch of defenses.
Yes,
I mean, there's
and
a lot of things
those were
checked
raised
off.
and discussed at trial.
Yeah.
At trial. So at this point, we are asking that the tenants are over $40,000 in arrears.
Yeah.
No use and occupancy has ever been paid, despite the fact that this matter has been going on since, I believe, February.
Well, I mean, I understand that, but of course, this is a bond hearing.
We would
Right.
ask that the amount.
Yes, in any other case, you wouldn't get your money till after the appeal, right? Or wouldn't get an executable judgment until after the appeal. But it's right. So I obviously, if you're entitled to the bond, you're entitled to it. But sort of course, they haven't paid. This is going on.
I understand. So, even the use and occupancy, which
well, the use and
to be paid as of
occupancy
June 1st.
is a different matter. The use and occupancy. If I affirm that starts when I don't know if I again, there's an answer to these questions that, you know, of when it runs from and how it works and what happens. So, but I do understand your arguments. This very well argued and very helpful to me, Attorney Poor, and you as well, Ms. Eduardo. And Attorney Poor, if you have nothing further, no?
Just that we ask that the bond stay.
Sure.
Thank you.
All right, the case is submitted. Thank you very much for coming in.
Thank you.
Honor.
Thank you, Your Honor.
Mhm.